Hi, this is Ed Sullivan and Mark Oberti of Oberti Sullivan LLP. We're answering questions about non-compete agreements in the state of Texas. Mark, a lot of non-compete agreements have a non-recruitment provision, which basically says that an employee, if he leaves employment with an employer, can't solicit, entice, encourage, or words to that effect, other employees who he used to work with or she used to work with at that company. Are these enforceable, and what should employees and employers, frankly, need to know about them?
Yes, those agreements are enforceable, and Texas courts don't scrutinize them as carefully as they do a non-compete agreement. So for the most part, a long, like 2-year, 3-year non-solicit of employee agreements have been upheld. And if you don't have one of those, well, then generally you can recruit your former co-workers at your old company. But even then, you want to play within the rules because the courts say, well, obviously, yes, you could call up, if you didn't have this sort of agreement, you could call up your former friends and truthfully tell them what your company has to offer and let them make a decision about whether or not they go to work there. But you can't obviously call them up and commit some tortious act in order to recruit them over to come to the new company. For example, say, oh, your company's getting ready to go bankrupt, or your company, we're getting ready to take their biggest client, so therefore you may not have a job there, in order to entice them over to the new company. So the main things to know about these clauses are, yes, they're enforceable. On the employer side, employers like to use them, and it's probably a good idea. From the employee side, if you're bound by one, you want to follow it. And even if you're not bound by one, in your recruiting efforts from your former employer, you want to be honest, and you don't want to commit any act that's independently unlawful to try to solicit them over.